I guess we owe Kirk some thanks for his cameo appearance in tonight's lecture. I think his recollection is foggy as well, but nevertheless, it doesn't matter whose recollection is right. Let's take Kirk's suggestion that 3 women from Founders Hall got really, really sick and ended up, in the hospital because of the lemonade we sold. What do we know from our lecture on torts about what happens in that circumstance? We know that without even proving whether we were negligent or not, that if we sold food that was tainted, that we would be responsible. And when we say we would be responsible, who is responsible? That's one of the fundamental questions about business organization. Who is it that's responsible for these debts? So, if in fact 3 women ended up in Founders Hall and they want to sue because they've been injured as a result of the tainted lemonade that they drank 52, 53 years ago, what then? Well, they need to start their claim by making a claim against the partnership. They say, well, we're going to sue Kirk and Craig's lemonade stand. And then if they aren't able to collect from Kirk and Craig's lemonade stand the money that they're owed, and let's just use simple numbers here. Let's suppose that they have hospital bills of $100,000. They sue Kirk and Craig's lemonade stand. That lemonade stand has as assets what, about a buck in cash and a couple of lemons that are going bad by the minute and maybe a pound of sugar. So they collect $1, $2 from the partnership toward the $100,000 that they're owed for their medical bills. What then? The what then is what makes partnerships such a dangerous form of business for people to be in. The what then is that each partner is responsible for the debts of the partnership to the extent that the partnership is unable to pay those debts. So, after the claimant has done the best they can against the partnership and exhausted their remedies against the partnership, they are then able to go against the individual partners. And they can pick and choose however they want. If they want to take it 50-50 from each of the partners, that's great. If they want to take the partner that seems to have loads of money and is driving a flashy new car and has money in the bank, that's great. They can go at it however they want, and they can take some from one partner and some from the other until the amount is fully paid. So partnerships have the partnership assets at risk, but beyond that, the individual partners have their personal assets at risk for the debts of the business, And this is a little terrifying. So, okay, let's go to the next slide. This is one that says partnerships, where it says we're going to presume they're 50-50, but that's not a requirement. If the partners agree between themselves that's going to be something other than 50-50, that's fine. Okay, but Kirk and I never really said it's going to be 50-50. We each put in something. The court, I think, would presume in that case it was 50-50. But that does not mean that the creditor needs to look at it as a 50-50 proposition. The creditors can look at it and say, we'll get it wherever we can get it. Craig's got money in his pocket, let's go after him. Or, Kirk's driving a flashy new car, let's go after him. Whatever they want to do, or get a little bit from both. Okay? Again, partners are free between themselves to change the amounts of contributions, and when they change the amounts of contributions, that does alter the relationship between the partners. And that is the partners may, as between themselves, have reached an agreement as to how the debts are going to be paid, but that is an agreement that leaves out an important party, and that is the person that's owed the money. Let's go to the next slide, and I think it'll be a little clearer. So the next slide should be, let's see, it says, I think we're at the slide that has a picture of a guy with no money in his pocket. It says, what about the partnership debts? Let's go to the next one. And we've got our 2 little stick figures, one of them saying, I'm only responsible for 10%, the other one saying, I'm only responsible for 90%. So the partners can agree that they will split the debts 90-10 as an example. That's permissible. But simply because they've agreed to it doesn't mean that the creditors have agreed to it. And since the creditors aren't a party to that agreement, it doesn't bind the creditors. You can't be bound to a contract that you're not a part of. So in this particular case, although the partners may have said, yeah, let's get in it, and you're going to be responsible for 90% of the debt, I'm going to be responsible for 10, that doesn't change the rights of the creditor, that third party that's out there that wasn't a party to the contract. And as a consequence, let's use the Kirk and Craig lemonade stand for just a minute. With that Kirk and Craig lemonade stand, if he and I had gone in and said, let's split the profits 90-10, and we're going to split the profits 90-10, let's just suppose we had that kind of foresight, we could have done that, but the individual women who were injured by a result of the lemonade can go after either of us for as much as they want. If they do, so let's just suppose that we had agreed that Kirk's going to take 90% of the debt and I'm only going to take 10%, and in the end I end up paying 100% of the debt because the women that were injured came after me and took it all out of my pocket. I'm then allowed to go and sue Kirk and say, hey, our deal was 90-10, I paid 100, so you owe me 90% of what I paid the creditors. So this relationship between the partners is still protected by the law, but the third parties on the outside are also protected by the law. So again, if you agree that internally that you're going to split it 90-10, and the reality is that it didn't work out that way because the creditors went to wherever they could get the money most easily, then the partners can then sue each other to enforce their internal agreement. Okay, so we'll go to the next slide, which is one we've already covered, and that is, you get the money. If you're a creditor, you get the money from the partnership. If that's not enough, you go after each partner individually. Okay, we'll go to the next slide, and this is where I've got the one with the guy on the tightrope, and it says partnerships, the most dangerous game. Partnerships are terrifying. You should be terrified of partnerships because they can arise organically. When I had the lemonade stand, I never dreamed that I had a partnership. I didn't call it a partnership. It just happened that the way we behaved that day created a partnership. And so there was a partnership. And then the second part is that there is unlimited liability for each partner for the debts of the partnership. If the partnership can't pay the debts, the individuals are 100% responsible for whatever it takes to pay the partnership debt. So this combination of being able to arise organically along with the unlimited liability for each partner is what makes them by far the most dangerous of all games to play in the world of business. Now, that doesn't mean you shouldn't be in a partnership. I've been in partnerships. They're not horrible. They're not evil. They're not something to be avoided at all costs, but they're something to only enter into with a great deal of care. Be careful about how you behave. Ask yourself, if I behave in this way, is that creating a partnership? Understanding that if it is creating a partnership, you're creating a potential great deal of liability, particularly depending on the nature of the business you're in. So, as an example, many years ago, when I was practicing law, I was in a partnership, Epps, Heckman, Walker, and Williams, and we had a partner who was a nice guy, but realistically, he wasn't a very good lawyer. And he wasn't a very good lawyer to the point that it started to worry the rest of us that he was going to be doing things that could potentially result in legal malpractice and result in significant liability for the partnership. And I guess I didn't really worry so much about the liability for the partnership as I worried about liability for each of us as individual partners if the partnership couldn't pay for it. So at that point, it really became necessary to have a heart-to-heart talk with that one partner and say, you're a great guy. I'd love to go over to your house for a barbecue. Call me anytime you want to talk about the football game. but you just don't belong in this partnership. And we had to ask him to leave, and he did. And it was not easy, but clearly for those of us that were in the partnership, that was the right thing to do. Okay, so we'll go to the next one, which is back to the lemonade stand. I think we've already talked about how this would play out with the lemonade stand with the unlimited liability part. Okay, so let's go to the next one, which is corporations. Corporations are something that you're all familiar with. We interact with them every day. They come from very, very large corporations to very, very small corporations. Size doesn't matter in corporations. There are thousands and thousands and thousands of corporations in every state that are potentially owned by only one person. There's nothing in the world wrong with that. And there are thousands and thousands of corporations that are owned by lots of people. So it's not size that makes you a corporation. It's the formality that makes you a corporation. You cannot become a corporation organically. Let me repeat that. You cannot become a corporation organically. To become a corporation, you need the permission of the state. The state says, okay, you've filled out all the right papers, you've sent us the right filing fee, you're eligible to be a corporation, congratulations. Here is your corporate charter. And they give you a piece of paper that says you've got the right to behave in a particular way. So formality, yes. Size, not really an issue. So let's go to the next one. Let's talk for just a minute about a short history of corporations. Corporations began in, the 1500s, and they've got kind of a mixed history in the Netherlands, in what was then Holland, and in England. And the notion was that people wanted to engage in what were extremely expensive ventures, and that is sailing from England or sailing from Holland and going halfway around the world to Indonesia to get nutmeg and load your ship full of nutmeg was an extremely risky venture. It was also an extremely expensive venture. You had to get a ship. You had to hire a crew. You had to load it with enough supplies to get to Indonesia and back. Okay, this is an expensive proposition. This is the kind of thing that it's hard for one person to take on that much potential debt. Now, obviously there are people that have that much money, and there were people that had that much money in those days, but it would be kind of nice to share the burden with others. So you start looking and saying, gee, I don't know if I want to be in for all of that, but maybe I'd be in for a third of that, or maybe I'd be in for a fourth, or maybe only a tenth or a 100th. One way or another, the notion was that people wanted to pool their money. They wanted to pool their assets in order to be able to afford certain risky ventures. And it made sense to pool your money for these expensive ventures, particularly if you had the advantage of, if things went horribly wrong, your only loss was what you'd put in. So let's take the things went horribly wrong and give it sort of a modern twist. Suppose we were doing the same thing today. We're putting together, everyone in this classroom kicks in enough money that between us we have enough money to hire a ship. We get a ship, we build a ship, we hire a crew, we send it to Indonesia to get nutmeg. Well, lo and behold, along the way, the first thing that happens on the way out of port, our ship runs into another ship and damages it. That ship is worth, we'll just make the math again simple. We've each put in enough money. There's $100,000 in our business to outfit this ship and hire a crew. We hit the other ship, and it's a bigger ship, and it sinks to the floor of the harbor, and it was worth $100,000. We get sued by the people that owned the other ship. They want $100,000 to make up for the fact that their ship is at the bottom of the harbor. Where does that money come from? If we were a partnership, they could have first gone to look at our assets and said, okay, you've got a ship that's worth, X dollars. Ours was a smaller ship, $50,000, we'll say. And, well, that's great. I'll take your ship. Well, they're still owed money. Well, I'll take all the supplies you've got on the ship. Maybe that's $10,000. Well, what now? Well, what about the crew? Well, we don't own the crew. We only hire the crew, so that's not really an asset that they can particularly grab. So how does that other party satisfy their debt? Again, if we're a partnership, they would then go to each of the investors and say, I guess I'll get it from you, or I'll get some from you and some from you and some from you and some from you. But if it's a corporation, which was this newfangled idea in the 1500s, what happens is each of the investors says, whoa, no, no, no. I just put the money in. I'm not here for you to take money out. What I put in is the maximum that I lose. If my ship sinks on the way to Indonesia, I guess I lost the money that I put in. But I'm not going to lose ever more than the money I put in. There is no way on earth I'm going to lose more than I put in. So we have the same format for corporations today. So as an example, several years back, General Motors, obviously a large corporation, General Motors was in deep, deep financial trouble. General Motors was unable to pay its bills. Eventually they went bankrupt. They've reorganized and they're back in business. But as they were in this position of not being able to pay their bills, if you were someone who owned stock in the General Motors Corporation, you owned 10 shares of General Motors. If you had 10 shares of General Motors, that didn't mean that the people that were owed money by General Motors could say, well, I started with General Motors, I tried to collect from them, they didn't have any money, so now I'm going to the individual shareholders. It doesn't work that way with corporations. With corporations, the investors are protected. They're willing to take the risk for the amount of money that they put in. If everything turns upside down and goes horribly haywire, I guess they lost the money they put in, but they will never lose more than that as investors. Far different than sole proprietorships, far different from partnerships. A much safer way for someone to collectively invest in a business. Okay, you can see in a world where there is unlimited liability, unlimited risk for things to go bad, that this is a much safer way to do business. Now, with corporations, let's see here. We should go to, originally we talk about the grant from the government. Back in the 1500s,